to hold more than 10 rounds that this court 10 years ago in Heller 2 observed were common. In fact, every circuit court to address this issue concluded that plus 10 magazines are common under any conceivable.
Let's get everything ready because, as usual, I'm doing this on the fly and don't have everything ready. So we're getting it ready now. Ron Guns, what's up, my brother? Let's see. Still trying to get. I've got the case up. I'm just trying to get everything else nailed down real quick. We'll give anybody who's going to show time to get here anyway. Do that. Close that. Ha. Make sure this is kicking. I really got to do a custom intro for freaking listening to oral arguments. Just because it would be cool. Anyway, Ron, how you doing today, brother? Oh, look, I'm live on Rumble. Let's see. Nope, that's the wrong damn link. Here we go. Copy. No, that's not right. Let me see. God damn it. How does that work? It is. Okay. I'll learn to spell one day, I swear to God. Give me just a sec, guys. That's the roughest thing about not having a damn everything set up and just hitting the stream whenever I can hit it. Because then I got to set everything up fast as shit and then I forget stuff. La da da da. All right. What? Romeo 1 battery only lasted 3 months? Dude, I would like to get a 43X. The only 43 I have is a 43 of one of the polymers that I built. And I just wish if that damn thing was like a 43 and was a double stack, and had better capacity, it would be a great, I hate to call them pocket guns, but way more concealable than a 19 or something like that. Maybe we can get through all this frame and receiver bullshit, and then we can get back to building guns again like we want to. Or hell, maybe one of these days I'll fire the printer back up and just print the damn frame I need. We'll see. All right. So anyway, we're going to listen now to oral arguments from today, DC Circuit Court, about the magazine ban. And there's oh hell yeah, Krabby Turtle, what's up, my brother? So we're gonna listen to this for the DC mag ban. Like I said, this happened today. So I'm juicing to do this one, and there were one or two other cases about the 18 to 20-year-old carry out of Minnesota that happened today too. Firearms Policy Coalition's been posting a bunch on it. They posted some links to it. I actually listened to one of the sets of oral arguments live today out of St. Paul. And it was really interesting to listen to that because it really sounded like these judges are not digging on the state's case whatsoever. It sounds like they are rather pissed just being there for the whole thing. Because in that case, part of the state's whole argument is, well, this person aged out. They're no longer underage, so the case doesn't count. It's moot. And I think it might have been FPC. They had more people in the pipeline for this lawsuit, and the lawyers for the state were arguing, well, they came in too late. They shouldn't be allowed. So basically their argument is we can just drag these cases on and mute them as they go, or moot them as they go, which is absolute horse shit. So let's crank up the DC mag ban. I've been waiting to listen to this.
Case number 23-7061, Andrew Hansen et al. Appellants versus District of Columbia, Pamela A. Smith. Mr. Wagner for the appellants, Mr. Patak for the appellates.
They're going to get their ass kicked. They're going to get their ass. At least there's any.
Good morning, Your Honors, and may it please the court. My name is Edward Wanger, and I represent the plaintiffs' appellants in this matter. With the court's permission, I'd like to reserve 4 minutes for rebuttal. The case before this court begins and ends with Heller, as clarified and resuscitated by Bruin. In Heller, when the Supreme Court struck the district's categorical ban on operable pistols, it held that the handgun ban amounts to a prohibition of an entire class of arms that is overwhelmingly chosen by the American society for that lawful purpose. Whatever the reason, they are the most popular weapon. A complete prohibition of their use is invalid under the Second Amendment. This case before the court involves an arm, standard magazines that hold more than 10 rounds, that this court 10 years ago in Heller 2 observed were common. In fact, every circuit court to address this issue concluded that plus 10 magazines are common under any conceivable definition of that word.
Are we bound by that determination in Heller too?
Yes.
No, Your Honor, but I don't believe on this
And
particular.
Bruin.
Why would we
Issue.
be bound by that? The
Well,
company-
if the court decides that.
No, I'm not asking you to say what I want to hear. I'm asking
No,
you
I
to
would-
tell me.
I would certainly, I would have no objection.
Oh man, I don't
if-
blame
I'm
you.
asking you have an objection. I'm asking you
What's up, Stan?
analytically.
What's happening, brother?
Well, there's Supreme Court certainly changed the intermediate.
Those are good, man. Those are pretty
scrutiny
dated.
aspect of that decision. Common use is an issue that remains under Bruin. And we found there on the record that there was common use of large capacity weapons, larger capacity magazines. So does that, I'm just asking you to tell me whether
Under the law,
that's still binding.
under the law of the circuit, Your Honor, I would say that is binding on this court.
So we don't
And-
have to wrestle with what on earth common use means, which many other courts have been dealing with.
That's correct, Your Honor. There's no reason to revisit that, and under that
That
really,
also answer the question of whether it's an arm.
absolutely does, Your Honor. I think so. And to the
I
extent,
think
that-
so. We didn't break that question out. I'm trying to
And
figure
no
out
kidding,
whether
Ron.
it's some kind of inherent in common use, but I could be wrong.
I don't think it's inherent in common use, Your Honor, but I think,
But common use is what?
well, common,
for common use for self-defense,
Mhm.
there's no reason to find as common use if you don't think it's an arm.
That's exactly right, Your Honor. I think analytically, and I think
So
just
those type
implication.
of, those aspects of Heller 2 are still binding on those.
Absolutely,
those
Your
sort
Honor.
of Analytical questions about usage and
Mhm.
those are binding. It's just
Correct.
intermediate scrutiny stuff that we.
That is correct, Your Honor. The only thing that was cut off under Heller 2 was the idea that you can means and scrutiny your way out of a fundamental right. So as I was saying, and as Judge Millett has recognized, these magazines are astoundingly common.
I just said a question. I'm going to say whether I recognize it or not.
No problem, Your Honor. The test is this, though. If something is a bearable arm, which it is, it's presumptively protected by the Second Amendment from any flat prohibition. The only way that the government can overcome that presumption is by showing that the arm is both unusual and dangerous.
Can I ask another thing?
This is just a
Sounds like you
frame,
have both,
you
as I read
these
your
facts.
plate, you have both a facial and as applied challenge. Is that correct? Or are we really here focused for the PI? Is it PI for the PI purposes? Are we just focused on the as applied challenge?
No, Your Honor. I think that the court is well within its rights to reach and say that as a facial matter.
Did you
This-
argue to the district court that you wanted a preliminary injunction based on the facial and as applied challenge?
Did, Your Honor.
Focus on the as.
I think that the focus was primarily on the as applied, but we didn't forfeit or waive the argument that this law is facially unconstitutional under the Second Amendment.
But my understanding also is that you agree that there's some level of magazine that could be prohibited as not in common use or not in common use for self-defense.
If that magazine is not in common use for lawful purpose,
For
then
example, so you're more an expert, far more expert than me in this. So what would that be? Would that be I mean, I know your
Nah,
clients
these are just
um,
standards.
range from
Not
I don't know,
coded.
6 or 8 to 18.
I think the problem.
And you said, I think you say that's sort of within the standard issue range. Would
Mhm.
30?
30 round magazines are common for rifles, Your Honor. I'd say that
But
for handguns, for the best-selling handguns,
handguns is sort of
that is the focus of this. But we
pretty
want to make
established territory. so
absolutely,
far.
yeah. But we want to make sure that we also recognize that 30 round magazines are in common use for rifles.
We don't have anything on the record for us.
No. But the best.
Okay, so we don't have
Yeah.
anything on that for the PI.
Okay, so for the purposes of the handguns, though,
Mhm.
some of the best-selling handguns we reference these in our briefs and put this
17
before the
rounds, 15
district court.
rounds.
Is that of the top 5 selling self-defense pistols,
15,
the 6-hour
13.
P320, the second best-selling pistol, that'll come standard anywhere from a 17 to a 23 round magazine. So if you're looking at that range, the focus really is, and the test is, are these commonly chosen by the American people
I'm
for
trying to figure out,
self-defense
so there's-
purposes?
For a facial challenge, you have to show that there's no application of this law that could be constitutional.
Right,
But if there is, and then we're doing this through a preliminary injunction lens, so it's
Mhm.
even, more of a burden on you than it may be at the merit stage. And that is, if you haven't argued here and you haven't created a record for PI purposes, not talking about what you could do on when you get to the merits, if you haven't
Found all
shown
good guys.
that 25 or higher is common use for self-defense and meets all the other criteria for protection under the Second Amendment, then your facial claim fails. Your as-applied one
Mhm. That's correct, Your Honor. Under
goes
that,
only
yeah,
up to 18 for your clients.
correct, Your Honor.
So facial's off the table for PI purposes.
Just for
the
PI.
likelihood of success. So we really are talking about an as-applied challenge. That's what this record has been for this preliminary injunction.
Absolutely, Your Honor, and we
That
acknowledge
range is
that.
kind of 6 to 8. I think the highest I saw for your
Cool.
clients was 17, but I think you mentioned things come out with 18. If we say 6 to
Right.
18 is the range for common use, and you say for self-defense, at least common use for standard issue is, let's say 6 to 18. Is that correct?
I'm not sure if I caught that question. You said
Sorry.
6 to 8?
18.
6 to
Not
18.
eight.
Okay, just
I
want to
know
make
you
sure,
wouldn't
yes,
say
because that would be a different
For
story.
your as applied challenge, what your clients have here. The highest I have them in the record is 17, but we could say 18 because I thought you put evidence in about some standard issues at 18.
If the inquiry is limited only to these clients, the record suggests that they
That's
want
for an
to,
as applied challenge.
correct, for the as applied challenge, their only focus, the highest that any of my clients possess, they want to carry in the district is 18. I want to
Okay,
make
I
very
thought it was
clear
17.
though,
Running a 6, we're doing pretty
Fine.
good.
yeah, 17. Well, I want to make
17 or
very clear,
18?
You're talking about
17 is in the record, Your Honor.
17 in the magazine or 18 including the one in the,
17 in the magazine plus 1 additional in the chamber.
We
To
don't-
be
we
very-
don't
yeah.
dispute that one. You can have in the chamber either way. So
Right.
then we're dealing with 11 to
So
18.
17, I think, is, for purposes of these
Yeah,
clients,
Red Dawn.
17 is the number. For purposes of the Second Amendment inquiry, common use is the watchword. And we would submit that common use goes roughly speaking to about 23 based on the record before the court. If this were a case about 50 round magazines,
But again, I thought
Yeah.
we got to the point where for the PI purposes, we're looking at.
I'm agreeing. No, I'm agreeing.
Oh,
I'm saying
yeah.
yes.
no, for PI
That's
purposes,
fine,
for
we're-
PI purposes, yes, I agree with Your Honor.
But in your colloquy in the district court, I recall you said 20. You would have a hard time defending more than 20 for a handgun or 30 for a rifle. Isn't that correct?
I believe it is, Your Honor. Like I said, whenever we actually looked in the record and we put into the statistics that are based on the sale of pistols.
About the-
Stupid these mag
That
bands.
is correct, Your Honor. Yes, the colloquy at the district court was focused on anything above 20 for pistols. For pistols would likely be harder to
Right,
justify.
so I think anything more than that is you're pimping away.
Pull my goon bean.
I'm not willing to suggest, Your Honor, that we've waived that. I think that that was perhaps one of the arguments. You know, we would like to clarify that a little bit if it were to go back down to, you know, for any additional evidence.
We're just talking about for this PI.
Cause you
Mhm,
honestly
yeah.
think gangsters.
So for
ain't
the
out there
PI
using
stage,
this
like I
shit?
said, our clients have handguns with magazines up to 17, and it was argued that anything
Hey,
over
Omar, what's
20
up,
would
my brother?
likely be a little bit harder
But as
to argue.
applied, it's going to stop at
Correct.
17.
Correct.
See why?
okay.
There's
Mhm.
All right.
So back to what I was saying, the test is this though. The only way that the government can overcome the presumption is by showing that the arm is both unusual and dangerous. And Bruin makes crystal clear that it's the government's burden at this step. The district court got it right, and I believe that this court will also, when it found that magazines are bearable arms under Bruin's definition, they plainly facilitate self-defense.
Michigan. What's up?
On
my
this
brother?
record, there are no fewer than 100 million, perhaps as high as 500 million higher capacity magazines that are in circulation in America today.
Is that the,
It's the English Declaration.
no, sorry,
That's-
what
yeah.
I'm asking is, are you talking about ones in sort of the 6 to 17 range?
No. These are the magazines that exceed
Oh, dude.
the
When
district's
we say
ban.
in circulate, what does it mean in circulation? Does that include purchases by the military and law enforcement?
No, these are civilian purchases, Your Honor.
Okay, are these law-abiding civilian purchases or non-law abiding?
Michigan
With
House
the
of Wayne Center,
caveat that
man.
it's the district's burden to prove that these are
Well,
not.
you're at a,
being
you want a preliminary injunction here.
That's true, Your Honor.
That changes the status quo and will inflict irreparable harm on the district. I know you have your irreparable harm, I'm not overlooking that, but when you want to change the status quo preliminary injunction, and as applied, and it will cause irreparable harm to the government and the public interest, you got some work to do.
Mhm.
And so
Warsaw,
when
what's
you
up, my
throw
brother?
out statistics for your as-applied challenge, it would help to have some more particularity, because if that number you just threw out includes ones over 17 or even over 20, if it includes rifle magazines, which
BV,
aren't
what's up?
for the PI, there's no record here that I've seen or arguments about that.
Yes, BV. The
If it
government being hard
includes
is not
criminal
our
and
issue.
non-criminal, law-abiding and, that's not the right way to say it, law-abiding and criminal or law-abiding
Right.
and not law-abiding.
Chamber, what's
Then
up, my
I'm
brother?
not sure how, that's what I'm supposed to do with that.
So to clarify, those are pistol magazines that exceed the district's cap.
Mhm.
I would
So
look,
those are
yeah.
all 10 plus.
Correct.
And the
So
district's
I would look
cap
at it this
is
way,
10,
even
right?
taking the bottom of that range, 100 million, there are at the peak, this is, cited by the Brady brief, maybe 600, 700 mass shootings per year. Even if every single one of those are considered unlawful purposes, you're still talking about a
There's lots
fraction
of other
of a
unlawful,
fraction.
those are horrific.
They are. And
Horrific, but there's plenty of, I mean, that's,
But
I assume
don't
the
get
flip
to
side of
strip
your
people's rights
self-defense
because of that shit.
rationale is that there are people who seek to do harm to other people. And if all they had were bows and arrows, we wouldn't need this, right? So they have guns. I don't mean to put words in your mouth. That was my understanding of what the self-defense rationale is,
fucking God,
especially in your reply brief when you were talking about.
I
so
was gonna
to
try to behave,
correct,
but-
I mean, I want to make
I
sure
have an idea
that
whether that statistic includes purchases or straw purchases for criminals, do we?
no, they're legitimate purchases, and that's established.
This is
They're
just
legitimate,
the-
sold to people who are
Just
allowed to
District of
purchase these. They can
Columbia.
go and they can purchase these.
You
So
don't, I mean,
Which
that's
is where
straw
Heller was
purchases too.
really, Honor, even if you include so let me be very clear. The rationale that the district, not only in this case, but even the district's Committee on Public Safety gave for advancing this categorical ban was that they wanted to make sure that you could prevent people from shooting rapidly and hurting a lot of people without having to pause to reload. That's the reason why I gave the mass shooting statistic.
Oh man.
Even if we look at all shootings,
Yeah.
115,000 is roughly
MC
the
stuff's
average
gonna
over
get
the course
stupid
of
up
1
there
year
for
in
a long
America.
time.
Even if every single one of those shootings included one of these higher capacity magazines, they certainly do not, that would still be roughly 2/100ths of the number in circulation that are being used for demonstrably illicit purposes. There's nothing more that we need to show that these are overwhelmingly commonly used and overwhelmingly commonly
Did you
used.
say demonstrably illicit or illicit?
Like banning cars.
They
to
are
get rid of
demonstrably
drive-bys.
used for illicit purposes.
Oh,
They are
okay.
demonstrably used for demonstrably.
Said the other one.
Demonstrably. No. They are plainly commonly possessed and overwhelmingly possessed by law-abiding citizens for lawful purposes.
And relevant lawful purposes, self-defense.
It's the way that Heller phrased it was lawful purposes like self-defense. That would certainly include self-defense training.
Well, the
Which-
district court in this case said self-defense was the operative one, at least again, for purposes of the preliminary injunction stage.
Correct.
Everything's
Yeah.
open on the merits. So
Heller is
we're
not-
focused here on self-defense.
Damn, Phoebe.
PI.
That is correct. And even in those circumstances, even if we limit the lawful purpose of self-defense, we still win on this record because I believe 64% of the people who purchase these and want to carry these have said that they want to use those for self-defense. And it makes sense given the notion that, as the district has pointed out, there is an uptick in crime. There are problems out there.
That's something I got to pause right here. And this is something we're seeing argued by the state and by the Fed constantly. That for something to be used for self-defense, you actually have to fire it. So they have to prove this person had an 18-round mag when they used the gun for self-defense. One, on just defensive gun uses, which most of those someone didn't have to fire a gun, but on the ones where someone did fire a gun, rationally, we win on that evidence any goddamn way. But you have these freaking judges. They will weasel through anything to try to get back to this interest balancing test to where, well, people are being harmed, so we really don't need these things. Again, ban cars to stop drive-bys. Tell me how that works out for you. Everybody's got to walk to work from now on. All cars have to be destroyed because there's just too many drive-bys. And drunk driving incidents, hey, we'll get those too. Same thing. Then we'll just have to be dealing with drunk horse riding, I guess. Christ, man. There's no IQ test to be a judge or to serve in government, and there fucking should be.
These are law-abiding American citizens who want to make sure that they can effectively meet force on force if the unthinkable occurs. So that's getting towards the,
Can I ask,
absolutely.
this goes to the balancing of the four factors. Why did you agree to a stay?
We agreed to a stay at the district court
Yeah,
because we
BB, you
felt
ain't
that
wrong.
the legal issues in this case were probably clear enough that if we brought this up on this record, the decision is a matter of law about whether or not these are covered, protected,
They've got all the
and
gun control in the
categorical bans
world.
are off
Y'all
the
be
limit would be
safest
clear
place,
enough for the
right?
court so that it would go back down. And that's the reason why we asked for
A lot of
entry.
confidence- a lot of confidence in us.
Well, we felt confident in our position, Your Honor. And for that reason, that's the reason why we've asked not only for entry of a preliminary
I
injunction,
think
but also
the distinction between the facial challenge and the as-applied challenge cuts in favor of not accepting your invitation to grant a permanent injunction, period, full stop. in the
Yeah,
case here.
it's
if the court is inclined to say that we want to limit this on this record to these plaintiffs before, we would certainly
I
ask
did,
for
brother.
a
I
remand.
just
We would
gotta
ask
activate it.
for, in the finding of like the success in the merits, that as a matter of law,
matter of fact, while we're
the
sitting
Second
here doing
Amendment
this, let
does
me.
not prohibit,
me
does
do
not
it, please.
allow this sort of categorical ban. If additional
I got busy.
evidence
and-
needs to be taken to satisfy this
Right.
court that the record supports that this is unconstitutional as a facial challenge, we would certainly welcome the opportunity to argue that on remand.
Let me take you back to Heller 2 for a moment. Seems to me that we didn't answer the common use question. What reserve?
I believe that the way that it was phrased was that it was a recognition that larger capacity magazines were common I think the actual precise question that was reserved, it was assumed that they were used for common lawful purposes.
Cannot be certain whether these weapons are commonly used or are useful specifically for self-defense or hunting, and therefore whether the prohibitions, et cetera.
Correct. So it was assumed but not decided.
But we need not resolve that question, however.
Mhm.
So we didn't.
That's true, Your Honor, but on this record also, I believe that the record is relatively indisputable. The district, I don't think disputes that as a matter of just pure numbers, these arms are astoundingly
I
common.
take the distinction, but
Correct.
insofar as you were insisting that Heller 2 resolve the matter, I think that's erroneous.
I think that the argument was that Heller 2 recognized that these were common. They reserved the question fully of whether or not they were commonly used for lawful purposes. That was how I read it. Obviously,
Yeah, I
Your
think
Honor
I'm in
didn't,
Warsaw.
so
But that is the key question.
Correct,
Even-
yes.
I mean, even if they're commonly used without commonly used for lawful purposes, it doesn't get you where you need to go.
that's correct, Your Honor. And that goes back to our argument that with the numbers of these in circulation, and even taking as a given the highest number of laws that could be broken, shootings that could occur with these are still overwhelmingly not used for crime. These are overwhelmingly used for lawful purposes. And of those lawful purposes, overwhelmingly used for self-defense.
When they are used for crimes, though, they are unusually lethal.
I would dispute that, Your Honor. Certainly, the concern about mass shootings and the focus on being able to shoot rapidly without reloading, to the extent that we're here and only talking about plus 10 pistol magazines, to Judge Millett's point that we're on the as applied level here, the ability to shoot that fast with a pistol is what I would suggest somewhat distinct from what I believe is happening with regard to mass shootings with the long guns and long rifles. That
These
said,
jokers
though,
never hit the thumbs up.
the
They are. I
fact
never
that
asked.
Heller considered that 70% of mass shootings were committed with pistols and still nonetheless
One
found
car,
that that
what's
was
up, my
not a
brother?
good reason, that could not overcome the Second Amendment protection for pistols in that case, suggests that that sort of cost benefit analysis, that sort of weighing the pluses and minuses, is something the legislators should not do and the court should not engage in. And Bruin really sort of reinvigorated that. They said that we've done, means and balancing from Heller to Bruin. And during that period of time, they realized that, means and balancing wasn't in accord with the history and tradition test that was set out. So those types of
there's
concerns,
no
the back and
balance.
forth about whether or not these are too dangerous versus whether or not common citizens should possess them.
Okay. I'm going to pause this for just a second. All of the balancing tests for the right for the people to own arms was done when they were going through the amendment process and writing the Second Amendment. They did all of the balancing then. And it was a legal document ratified, accepted by the states. And although most states have protections for it anyway, but all that balancing was already done. There's no more balancing. Once it was agreed to, this is what we agreed to. That's it. That's where it sits. So, and when they're getting into this balancing test, and that's how we lose a lot of stuff, because they go with intermediate scrutiny so that they can do this balancing test. All these things get used in crime, so people don't need them. Law-abiding citizens, they can just suck hind tit and I guess use single shot break actions or something like that. That's not how this works. The balancing was already done. You can't change the terms of a legal contract after it has been signed on to and agreed to. I've used the example before. I can't sign a contract with you saying I'm going to bring you a green apple every other Monday for the rest of my life. And then all of a sudden just say, fuck it, I'm going to start bringing you oranges. You agreed to apples. I agreed to apples. We both signed a contract. We both agreed to it. And I don't know, maybe you hit someone in the head with your green apple. So I decided, fuck it, oranges are softer. No, it doesn't work that way. Any judge who argues about that, any judge who says that these things can change, will do that for any right, whether it's your right against illegal search and seizure, you name it. They will argue away any of your rights.
Is something that Bruin took off the table.
So it
What's
must
up, Vanessa
be
Kitty?
considered Into historical.
Correct, but common use means that there is no historical tradition. If there was a historical tradition of a categorical ban on these arms, they would have never come into common use for lawful purposes. That's how the common use test fits into the historical tradition Bruin test.
Well, you're all right, unless I froze you once.
Okay, just a couple more questions. First, just a fact one. How long have your clients been residents of DC?
Years, Your Honor, I don't have the precise number before me, but they've been here for a while.
When you say years, does that mean 3, 5, 10?
I can confirm that whenever I sit back down before rebuttal.
Years.
I don't have that information directly before me.
More than
Oh,
one,
I'm sorry,
more than
what-
two
How long his clients have been, the as-applied clients here have been residents of DC?
years.
I'll get that information for you if
No.
it's
But
an
it wouldn't
hour.
matter if they were only there
And
for a
then,
month.
One thing I'm curious about is justices have said many times that banning automatic weapons would be considered
This is about the 10-round
history
mag
and
ban.
tradition.
Ma'am.
Um,
HPS, what's up,
Given
my
that
brother?
those did not come on the scene in any significant number, any materially significant number until the 20th
Oh, dude.
century, what tradition of regulation are
If I wasn't on a bunch of lists
In that
already,
particular instance,
I
Your
would
Honor, I
get
think that
paid.
that actually is an example of the government getting regulation correct. As a historical matter,
When did that regulation by government start?
so I believe if you actually look at, it was in the
I have
1930s.
MVE
And the
symbols
reason
all
why I
over
want to
the
make
place.
sure that,
1930s don't count.
pardon me,
I thought your brief said 1930s don't count.
like
they
that.
don't. And for purposes of this, I want to make sure that the court gets the timeline correct because even granting that they're looking at this from the early 20th century perspective, either way, the history and tradition, the citations need to somehow key back into the initial understanding of the American founding. The reason why Tommy guns or machine
Yes,
guns in
Juan Carl.
particular are different is that they hit the civilian market in 1921. Those guns, and this is actually recognized by now Justice Kavanaugh's dissent in Heller 2, those guns were a commercial failure. They did not sell. They were overly and prohibitively expensive. The people who bought those were the criminals, were the mafiosos, and they were using them for perhaps, as an example, one of the most infamous mass shootings that the world had seen, the St. Valentine's.
The St. Valentine's Day Massacre. I already know where it's going to go with that. Yes, machine guns were extremely expensive. They were very hard to manufacture when they first came out, which drove the cost up. They were never banned. The government just, and they said it in the hearings for the 1934 NFA. They went through the arguments for this, and they said, look, we can't ban these guns. That would be unconstitutional. So what we are going to do is we are going to tax these things. And then they argued about the tax and the amount of the tax, and they finally came up with the $200 because the $200 was roughly the cost of the machine gun itself. Now understand, at that time, there were no background checks. So what they did was they took a gun that basically criminals were the ones that could afford it in the first place. They drove the cost up, and criminals could still afford them and still get them. They didn't stop shit. What they did do was take a lot of law-abiding people, or mostly law-abiding people, and fuck them over, which is what all of these gun laws do in the first place. At the time, the 34 NFA, you could still pay cash on delivery and have the gun mailed to your house, dropped off on your front damn doorstep. And then you just had to do the tax pay, or you had to pay the tax paperwork, I think, when you bought it, and that legaled you out. But again, you were talking about prohibition era gangsters. Do you honestly think those sons of bitches were worried about a $200 stamp? They're going to go line people up against a wall like the St. Valentine's Day Massacre. They're not worried about federal stamps and laws. That's how ignorant these fucking gun laws are in the first place. And when we get into magazines, well, yeah, DC's got a 10-round magazine. This is one of those, 30-round sticks, as they call them. every little gangster you see on their little videos is running around with one of these in their Glock with a fucking switch on it. Why limit the people who are out there not causing harm because the people who are causing harm are causing harm? Oh yeah, fuck, the mafia still got politicians in their pocket. But our government is the most successful crime family in history. So, what'd you say, HP? Crime Owners Protection Act. Yeah. If the NFA wasn't like it was, and if they didn't, especially when they banned new manufactured machine guns, if they didn't do that, I'd have plenty of machine guns. I'd be able to build the sons of bitches and just form them, tell the government, hey, I built this, or I'm going to build this. Here's my stuff. But there are a lot of people heavily invested in machine guns. And if they ever got rid of the amendment, was it Hughes Amendment? Yeah, Hughes Amendment, which banned the new manufacture of machine guns, their $40,000, $100,000 machine gun would be $1,000, couple $100, and they don't want to see that shit. So there are some people heavily invested in this stuff. They don't want to see that amendment go away. But you're right. And there are hundreds of thousands of machine guns in perfectly legal hands all around the United States. You do not see them getting used in crimes. They just price someone like me out of the market is all they did. Because I don't have 20 grand, 25K to drop on a full auto AK, even though I could literally build the son of a bitch for $600. As long as I got a good price on the parts kit. It's ridiculous. Gabriel, what's up, my brother? Let's get back to this dumb shit.
As they massacre. That happened in 1929. The bans that some states experimented with, which to be certain were very, very few and far between. There were 4 bans. And the federal government deciding not to ban, but to regulate the sale of automatic weapons happened in 1934. So that was rapidly changing
They
technology.
can't be banned, they can only be regulated.
That's our position.
Yes.
Mhm.
We would,
But
we would
it's
well,
not what.
so let me,
So I'm still trying to answer my
Correct.
question.
Mhm.
I understand the timing and the history,
Jesus.
but then the
Lord.
language that has been used by justices has been they fit within tradition. And under Bruin, tradition means that I go back to find something at the founding that has a sort of same how and why.
Mhm.
So what is that
Yeah, I hear that,
tradition for
HB.
automatic weapons?
for automatic weapons, I think that the only wiggle room for the government to categorically ban those would have to be really stretching the
What
dramatic
Tradition
technological
was
change.
just what the justice is referring to.
For purposes of automatic weapons, it's not clear.
M16s and Heller, so maybe they're wrong. It
Yes.
wouldn't be consistent with history and tradition to ban automatic weapons.
No, not at all, because there is some wiggle room for dramatic technological changes in the precise when they speak of, and when Heller spoke about
Agorizer, what's
M16,
up, my
they
brother?
underscored that those were, and I quote, highly unusual in society at large. So to be able to actually key that back in, I haven't litigated myself an automatic weapons case. I don't know
I'm just trying to
exactly.
figure out how
Yeah.
after Bruin, you can have a type of weapon that
Let me
technologically
look up something.
wasn't even a twinkle in any gun owner's eye at the time of the founding or even Civil War. The technology just wasn't there, and that technology
Yes, it
doesn't
was.
materialize until 21st
Oh,
century.
it was there before.
And so, but everyone, other justices, I think, Heller was majority opinion, feel pretty
Correct.
confident
Mhm.
that prohibitions, of course, even for regulations, you're gonna have to make the same type of showing
Right.
under Bruin, all fit with this history and tradition. And so we have arguments here and arguments on both sides, to be clear, but arguments on like one side that sort of the semi-automatic weapons, the rapid fire, high capacity, they have is a much more modern innovation. But yet they have to try to find, this is your argument, they have to try to find something back in time that parallels that. And so what I'm asking you is,
That is why the Constitution listed arms. It didn't list the right of the people to own a single shot musket or the right of the people to own a blunderbuss or anything like that, because the founders knew technology changes. And yes, lady, there were machine guns back then, but again, they were just so expensive to manufacture that it was cost prohibitive. You could arm entire troops of soldiers with the modern rifled musket before you could get one machine gun. And it was better to have more guns in hands at that time. That's the reason they didn't go for the puckle gun and a few other designs. Do you honestly have to get your fucking brains knocked out to be a judge? Honestly, do you have to? Is it a requirement? It can't be, because there are some judges that actually have some fucking sense and could do a general Google search. But her idea is guns are bad. Guns are always going to be bad. These magazines are bad, and that's all I'm going to go to is they're bad, 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 bad. I wish I had the steps in place where I could have been a lawyer earlier in my life and went through that. And I ain't ruled the shit out yet. But I really don't think a judge would like me standing in the courtroom going, "Are you a fucking idiot?" I'd have to find a better way to say that. Did you just slap me in the face with a fucking stupid stick? Because Jesus. Yes. Yeah. I mean, technology apparently doesn't matter with firearms, so it should matter for other rights. So, yeah, bitch, write your decision with a quill and pen on parchment and then send that shit Pony Express to get it somewhere, or have a courier or whatever. Don't email the shit. Don't put it online. I was going to behave. I was really, really trying to behave.
you aware of any back in time parallel that's relevant for automatic firearms?
I am not standing here, Your Honor.
Multi-barrel
I think
fire.
it really emphasizes also that even the categorical bans on automatic fire weapons are astoundingly exceedingly rare. At this moment, to this day, if
I'm
you're
just
allowed,
asking what the justices were, what history and tradition they were relying on.
that part of it, I don't have the answer to, Your Honor. But what I can say is a historical matter. Automatic weapons are not categorically banned. You can get them. You can jump through a lot of hoops. They might be prohibitively expensive. The average citizen, the average law-abiding citizen, can still get those
Okay.
for purpose.
Let's hit this real quick. And I'm going to use CNN for a fact check here. Because if CNN can unfuck themselves and get this half-ass right, God knows the rest of these people should. So where are we at? People in more than 2/3 of the states are allowed to own and buy fully automatic machine guns as long as those guns were legally registered and possessed prior to 86. More than 700,000 legally registered machine guns in the U.S. as of May 2021, according to official federal data. 200,000 was good enough for stun guns to be in common use. This is 700,000. And it's closed market. You'll have more guns falling off of it than more guns coming into it, because there are very limited ways that a machine gun can come into the market. Richard Hoffman used to be on the show with John Crump and Flying Rich all the time. They explained ways that some semi-automatic Uzis could actually turn around and be registered and be legal as full autos. And there are some still finds of machine guns. Granddaddy had it. Grandpappy had it. They can show provenance of it. They can get that legally registered. There's a very few circumstances where they can come into the market. But even with all the guns falling off the market, because that market is dwindling faster than it is gaining numbers, still 700,000. I'm a welding instructor. If I can find that in just a second or two, you think people who are making really life and death decisions on these cases would be able to unfuck themselves long enough to get the information. HK 416. Yeah. Shit, yeah. I'd love them. I'd love full auto AKs and could build them quite inexpensively, depending on what the base kit was. But I can't do that and be legal because of dumb shit. And remember, this is all about the magazine ban, but they're tap dancing all over this other shit. It just you seriously think the little gangbanger out there, he's gonna forgo the 20-something, 30-something round mag that he's got and go, oh shit, I can only have, hold on. Fuck, do I have it? I don't, well, the only 10-round mag I got next to me is a 10-round AK mag. But yeah, you think that gangbanger who's going out there selling drugs and shooting people and all that is worried about your magazine limitations. Yes. Open bolts, which you can have open bolt guns, but I would so love some open bolt full autos, Stens, and yeah, TPSH. Yeah, MG42, yes. G40 or FG34, oh, M60. Definitely the M60. Definitely big. Later, Gabe. According to CRS's cases, line drawings are illegal. Bitch. Go to jail. No, the line shouldn't be there. Yeah, I'm hearing it a little bit before you guys. Let me do something that way. Um, no, I really do it that way. I just try to keep my mouth shut.
A rifle might be better for home defense. And
Pistols
what
and
Heller
rifles are
said,
categorically different in very, very many different ways. Here, we're just talking
But-
about number of bullets.
but I
And you
reiterate,
agree that there's a number of bullets that they can ban.
well,
you agree
certainly
that.
those that are not in common use for lawful purposes.
Let me
and that
back
is
this up
their
a little bit.
burden to
Okay.
show.
We're gonna
where
say
that line
common use for
lies.
Self-defense today, this morning, for
I might back it up a little too much, but I'm going to back it up a little bit.
purposes of the PI.
Correct.
Hey, come back here.
Okay.
But I
What?
want to,
If
So,
it's
yeah.
as simple as that, what role
We're just going to have to pick it up here.
Bruin
It's being a
does
G.
the passage about dramatic technological change, or perhaps more important, unprecedented societal concerns? What role does that play in the analysis?
I think part of the role in that analysis is keyed into the idea that Heller itself dealt with a categorical ban on a class of arms. The issue in Bruin was where could you carry certain arms? So they had to go through things. For example, the issue in that case was inside versus outside. An example of a dramatic technological advancement would be, okay, does the Second Amendment protect people to carry firearms through TSA security? Certainly you have similar concerns. There might be an analogous history and tradition of banning arms, and they recognize it in sensitive places. Taking Bruin under the four corners of the issue in that case really sort of informs why it was that the court was so focused
We
on
back good
dramatic
on the audio
technological
now.
changes, perhaps airplanes, and societal concerns, 9/11. So in those circumstances, the historical analysis becomes a little more acute. Heller, though, said that as soon as you have common use for purposes of today, self-defense,
So Bruin comes after Heller.
correct, it does. But Bruin really clarifies Heller.
Absolutely,
That purports to
Alvarez.
clarify it. I'm not sure whether it helps
Yeah.
me.
But the clarification there, and I think it really is this, is that when you're talking about categorical bans on arms, arms are indisputably used for self-defense. The government cannot satisfy based on the history and tradition test articulated in Bruin.
Suppose that unprecedented societal concern arises after something is in common use.
Under that circumstance, Your Honor, the Second Amendment is interpreted in Bruin suggests that is still protected under the Second Amendment.
So the arising of some unprecedented societal concern just has to go unredressed or ignored if it involves something in common.
Not at all, Your Honor, because the legislature has other tools. They have tools short of a categorical ban. I'm not going to
But why wouldn't
prejudge.
your argument apply just as much to regulation? If they couldn't find the analog, you've got common use, unregulated, at the time they act. They can't find some 1792 law that regulated this thing that did not exist remotely, comparably. How are they going to do it?
Well, for instance, in this case, if you're talking
I'm going
about,
to challenge the regulations too.
pardon me, Your Honor?
Folks are going to challenge the regulations too.
They are, Your Honor, but I think that if I were up here and if, for example, the district had said that the only people who can possess plus 10 magazines are folks who have a concealed carry license, and they've gone through the training and demonstrated, be a very different case. We would have a much harder challenge to try to say that.
You'd still say it fails the Bruin test.
Not necessarily, Your Honor. I'm not prepared to say that. I don't think that it would
How would it
because concealed carry licenses, that's something that Bruin actually recognized are longstanding. Bruin didn't throw out, for instance, the concealed carry license scheme. It actually said that for as long as it's a shall issue scheme, we're not disturbing those findings. They didn't prejudge that at all. That would be an extraordinarily harder case.
So Bruin
make-
would allow the district to say only those who have concealed carry licenses through, let's just assume you're not challenging the regulatory scheme.
Correct.
For that, of a 6 magazine, that'd be perfectly fine.
Could you repeat that, Your Honor?
But the
For-
magazine would only be 6, not more than 10, not 10.
I'm not
No,
sure if I completely follow your question.
So I'm following up on yours. So you
Right.
say, if you had a case where they said concealed carry, high magazines, 10+ magazines are banned except for individuals who have concealed carry permits, have been through all our safety requirements, background checks, law-abiding individuals. They're all banned, but as for those individuals, they may carry magazines up to 6.
Up to 6 or 16, Your Honor.
6.
So individuals who have, that would still
Your best golden individuals.
can only carry 6-round magazines? No, Your Honor, that would not survive Second Amendment scrutiny because you're still categorically banning a wide swath of people from possessing commonly held arms for lawful purposes. That would absolutely, under our theory, fail the Second Amendment's test.
Thank you very much. Here's some time
Thank
for
you.
rebuttal.
Thank you, ma'am.
May it please the court, Ashwin Pathak for the District of Columbia and Chief Pamela Smith. And let me start with some of the colloquies that Judge Ginsburg and Judge Millett had with my colleague about Heller 2, because I do think Heller 2 is quite important in this case. And I agree with you, Judge Ginsburg. I think what the court did in Heller 2 is that there were basically two paragraphs that talked about common use. The first paragraph in Heller 2 talked about whether or not they were simply numerous in society. And everybody agreed in that case that, of course, large capacity magazines are numerous in society. There are millions of them out there. And then the court went to the second paragraph and it said basically that there wasn't enough evidence in the record to determine whether or not large capacity magazines are in common use or used specifically for self-defense. And it said that it would have to remand for that question to be more fully fleshed out with evidence. But then, of course, the court went on to apply means and scrutiny, an analysis that has been repudiated by Bruen. And so I think it's very indicative that the court did that, and it's highly persuasive for this case that even Justice Kavanaugh in dissent, in the footnote at the end of his opinion, he too said that he would have remanded on this question. Everybody acknowledged in that case that there were millions of large capacity magazines in circulation, but even he would have remanded this case to figure out whether or not they were actually in common use.
Seems like sort of a dim view of the American public, right? This could be so popular, so common. Could be the standard magazine that comes with the quintessential self-defense gun, to quote the Supreme Court. And yet, even though it's standard for the standard gun, it might be only in common use for unlawful purposes.
Well, I certainly wouldn't suggest that it's only in common use for unlawful purposes. But what I would say
So
is that
it in common use for lawful purposes?
well, I think it's in common use for all manner of reasons. Folks might like to collect them. They might like to have them. They might like to shoot
It
them.
seems like it has to be in common use for lawful purposes when it's the standard magazine for the standard gun. Unless you think the standard American is out for unlawful things.
I don't agree with that, Judge Walker, because I think it proves too much. I think there's 700,000 machine guns out there. Folks have them as collectibles. They have them because they like to shoot them. They may even have them because they subjectively think,
I think a lot of them are owned by police departments and government, right?
and many are owned by collectors and
We're talking
individual
about,
citizens.
I don't know how
And
many are owned by.
I don't think we have that specific number in the record, but I will just say,
500 million high capacity magazines. It's a lot of magazines.
I understand that, Judge Walker, but I think it can't just be a numerosity analysis. If the court in Heller and Bruen had thought that numerosity was the beginning and end of this test, those decisions would have been very short because they're the same number of handguns out in circulation. But instead, the court went through in Bruen a two-part analysis, step 1 and step 2 of Bruen, which started with a threshold inquiry that in our view applied the common use for self-defense test that is fully consistent with what this court believed was the test in Heller 2. And I'd point the court to 2134 of the Supreme Court Reporter, that's section 3A of that opinion, applying the test that it had previously set out to carrying handguns, where the court said in that very first paragraph that everybody agreed in that case that handguns were commonly used today for self-defense. That's the language the court used there. And we think it has to be something more than numerosity, because if it's pure numerosity, that results in a circularity that is simply untenable. I don't understand how it could be the case that there are 700,000 machine guns in circulation, that more than the 200,000 stun guns that Justice Alito mentioned in Caetano.
You don't know how many machine guns are in private hands.
It's certainly, they have not disputed that it's hundreds of thousands. Nobody has disputed
Can I
that.
take a
in
step
this
back and
case.
tell me, I'm going to walk through what I think is the test, and then you tell me where I'm going off the rails. So I think you start by asking, is it an arm? Is it an arm in common use? Maybe even you can extend that to, is it an arm in common use for lawful purposes? Maybe even is it an arm in common use for self-defense?
Correct.
And I know you think you win already, but let's then say I think the answer to those things are yes. Then I think there's a history and tradition inquiry that says, is there a history and tradition of this regulation? And for example, one history and tradition, I think the Supreme Court may tell us in a few months, is for unusually irresponsible people, there is a history of keeping guns out of their hands. I think the history and tradition that you're relying on, since these exact guns weren't in existence at the time of the founding, but you need not a twin, but an analog, is there's arguably a history and tradition of banning unusual guns. We could add dangerous to that if you want, right? Dangerous and unusual guns. And so
What's up, brother?
then
Ford?
I
What's
think
up?
that means, okay, well, we need to find a history of that and a tradition of that. History being, we need to look to the founding era, or maybe if we're in 14th Amendment incorporation world, 1868 era, but we're not here. Say, okay, do we see founding era, colonial era bans of guns in that are unusual? And if so, is there a tradition of it? Is it an outlier or is it kind of widespread? And let's say that I'm with you, that there is a tradition, history and tradition of banning guns for the purpose of preventing gun violence, a tradition of banning guns that
100%
are
accurate.
unusual, dangerous and unusual.
But
Then
they
you
only
still
want
have to show
one
that
fired
this
for self-defense.
arm in question is unusual, right?
Well, I think I would have a disagreement with how you're characterizing unusual. If you're using unusual in the colloquial sense, that is it numerous in society? Are there a lot of that weapon? Then I would disagree with that's the way that this standard has to apply. And I think the problem with that is, first of all, it doesn't comport with the historical tradition. Bowie knives, I think, were quite popular and numerous at the time that they started to be regulated in the 19th century. Nevertheless, nobody thought there was any Second
I
Amendment
think they
issue
weren't
there.
banned, right?
They were eventually banned in a lot of jurisdictions by the end of the 19th century. I agree that some of the earlier restrictions are carry restrictions and other sort of severe regulations on those types of weapons.
Related with dueling.
Yes. No, that's right. But I think it cannot be that unusual is simply a sort of a redo of the numerosity analysis.
Well, it's not a redo if we're talking about something like banning unusually irresponsible people from having guns, because that's we're not talking about whether the guns are usual or not. That's a totally separate inquiry. But when the tradition that you're talking about is a tradition of banning dangerous and unusual guns, then I do think that that inquiry is going to be very similar to that first inquiry of, is the gun in common use?
The problem with that, I think, Judge Walker, is that I'd point the court to the Seventh Circuit in its decision in Friedman, pre-Bruin, admittedly. It noted that machine guns were all too common at the time in 1934 that the National Firearms Act passed. Nevertheless, the Supreme Court told us in Heller that it would be a startling, and that's a quote from the decision, proposition that those types of weapons, the same is true for short-barreled shotguns, that any of those types of more militaristic, offensive, high firepower types of weapons or weapons accessories couldn't be banned.
I take it the Seventh Circuit said that, but my impression is that the machine gun was not the standard quintessential weapon of self-defense at the time it was banned. That it was actually Congress stepped in at a time when it was still pretty unusual, if you weren't a mobster, to have a machine gun.
I understand that, Your
Yeah,
Honor.
this was
I think
today.
there's
It's not
two
live
responses
now,
to
but
that. The
this was
first
today.
is, I think around that same time, there were actually a number of different bans on large capacity magazines that went into effect as well. We obviously quibble with our friends on the other side about which one of those count as bans or not, but I think at the very least,
Which one do you think, what's your best example of?
I think
Not just a carry ban of a high capacity magazine, but a total possession ban of a high capacity magazine outside of DC.
Rhode Island, Michigan, and Minnesota, all reading the plain text of them, seem to me to be bans on large capacity magazines. Ohio and Massachusetts and Virginia all had regulations of them in various ways.
I thought that Rhode Island, Michigan, and Minnesota combined the magazine cap with the mode of fire. So for example, a high capacity Winchester, like lever action rifle, would not have been banned by those states, but they would be banned by DC today.
I'm not sure that's right. I think there's an or in the Rhode Island provision that makes it seem like it's either a certain capacity or automatic feature. So I don't think that's quite right. A couple other examples I'd point to would be that the model code for machine guns that was circulating at that time.
Those aren't statutes. And even if I give you Rhode Island, Michigan, Minnesota, didn't Bruin say 3 is not enough? Probably 4 is not enough, 5 is not enough.
Well, I think the problem here is that it would lead to really absurd consequences. It would mean that if the National Firearms Act had been passed in 1954, 20 years later, which could have been a reasonable response. You know, Congress might have thought, let's let this percolate, let's let states decide, and then make a decision. In those 20 years, if a number of machine guns, far more machine guns had circulated, which I have no doubt that they would have, suddenly plaintiffs would be coming in and saying, hey, Second Amendment now comes in, and the scope of the Second Amendment has now
It
changed.
actually seems like a pretty decent proxy for what's dangerous and unusual. If it's dangerous and unusual, we would expect our legislatures to step in and ban them before they become dangerous and usual.
Again, I think I would just reject that type of circular argument. I think it means that it sort of puts the cart before the horse, and it incentivizes, in my view, over-regulation by governments. I mean, it basically means that governments, if they want to try to ban a particular weapon but don't know societal consequences of it at the time that it comes on the market, governments would really be incentivized to come in and say, you know what, we're going to just ban this now, because we know if we let too many of those come out, if we let more than 200,000 or 700,000 enter into circulation anywhere and in any state in any part of the country, we are going to be forever precluded from dealing with that weapon, from regulating it heavily or banning it down the road if we find that that weapon, you know, does lead to really serious consequences, which we would say large capacity magazines have. And I'd add,
There also, I wonder if there's a circularity or catch-22 or whatever it is. If something gets out and is, for example, like the automatic guns, and automatic machine guns used by criminals,
They're already out. Where you been, lady?
is there not likely then to have a reaction? And let's say that when they come out, they're deemed to be quite dangerous in a constitutionally relevant sense, in a way that firearms otherwise normally in civilian use are not. But once the bad guys have them, people want to have the same thing to protect themselves. Nobody wants to go up against a machine gun with a 6-shooter, right?
correct.
So, so there's equal risk that the response by people is not that
It's
we
funny.
only need these for self-defense because
Someone posted
the government
me.
has let them out
Yeah,
there.
right.
The government doesn't let, or at least enough that like criminals have them. And so it just, I don't know how any of this allows us to make analytical questions about what people really want for self-defense or desire or need. If there's simply this endless response to someone else has something more, you know, manufacturers put out higher magazines, I need a higher magazine.
For me.
New iPhone comes out, I gotta have a new iPhone. New magazine comes out, I gotta have a new magazine. And so as the inquiry, how do we do the inquiry then about whether they're used for facilitating self-defense without it turning into an endless, well, if criminals have them, I should have them facilitating my self-defense too,
Look at
so
the
that we
number
now
of
have
them legally
automatic
sold, lady.
weapons, and before long grenade launchers in everybody's house.
I totally agree, Judge Millett. I do think that there is an arms race that would develop if the only standard is what people sort of feel they need to respond to certain criminal activity. So this is why we've put, we've made the point that in our view, the standard is essentially what is in fact commonly used for self-defense. And I think you can look at that in a couple different ways. You can look at it like Heller looked at handguns. What are the actual characteristics of handguns that make them useful for self-defense? They can be grabbed quickly in a self-defense situation. They can be held with one hand while you call the police. On the flip side, you can also look at how are large capacity magazines or any firearms actually used in self-defense situations. And on this, we've put evidence in the record that has been unrebutted by plaintiffs at this sort of preliminary stage without much evidence in total, that really in the average self-defense situation, 2 to 3 bullets are fired. It is rarely, if ever, that more than 11 bullets are fired in a self-defense situation.
This argument in and of itself so fucking ignorant of reality. It's not even funny. Because see, here what they're doing is they're actually acknowledging all the defensive gun uses where someone doesn't fire their gun. They're averaging those in with people who actually fired their gun to drop the number of rounds that they use in an average engagement. They play with these numbers so fucking hard. And these judges, the anti-gun judges, are just so hell-bent on banning any damn thing that they just refuse to do the very basic research to go, hold on, you're full of shit, because I can go find videos. Well, one, there's two different things going on. I'll say this. Go watch most police engagements. They basically mag dump from the rip, just going. Average self-defense shooting, people are very much trying to conserve ammunition. They are very much trying to control every round that they shoot, because they know good and damn well there is a lawyer attached to every one of those fucking bullets. There's two different mentalities there. Cops tend to mag dump people where they might shoot fast. They don't tend to mag dump quite as much as cops do. But again, they're still factoring in all the shootings where no one fired, or all the not shootings, but all the defensive gun uses where someone didn't fire the gun. They're factoring all that in here to drop those numbers down lower. It's mind-numbing to me. Whether the only reason these judges agree to this shit is they're anti-gun in the first place. That's the only reason. They are looking for a reason to uphold the state's case. And see, to me, judges should be the one that are basically there for the people, that are trying to uphold the people's rights. And that's coming completely flipped on its head. Now they're just completely trying to uphold the state's power. It's I don't lost my
Now,
mind.
obviously, these are sort of proxies for trying to determine what is in lawful use for self-defense, but we think they're objective measures of that. It cannot be that it's just a subjective test, because subjectively, citizens may decide they want a machine gun for self-defense, they want a grenade launcher for self-defense, and they may really subjectively believe that that is making them safer, that having that in their home and having it at the ready is making them safer. That would sort of lead to a rudderless test that would just be whatever weapon is most popular.
Everyone's talking
There's
about
no such-
standard issue,
everything's taken
standard
care of in the
issue,
Second
which I
Amendment.
assume means that's what the manufacturer
Period.
puts with it. When
Right.
did manufacturers start selling magazines over 10
My
with the semiotic?
Okay, let me check.
My
bro.
understanding is that
Handguns only. Mhm.
is that semi-automatic handguns were not equipped with large capacity magazines until at least the 1980s. And I don't think plaintiffs dispute that. So it is quite a recent
Explain the
development
Browning high
that
power.
semi-automatic handguns, not rifles, were sold with or generally could even take a large capacity magazine. And you really see when that happens in the 1980s, which is a very recent
That looks
vintage,
good, brother.
that leads almost immediately to sort of what has become the modern scourge of mass shootings. And very quickly thereafter, in 1989, California imposes a large capacity magazine ban. Right
And they
after
still
that, in
have mass shootings.
1994, the federal government imposes a nationwide large capacity magazine, which I might add is the 10-round number that the district uses today. That was in effect for 10 years. The moment it went out of effect, a number of states have slowly sort of adopted those bans as mass shootings have continued to happen across the country, usually using a large
Completely
capacity
disconnected
magazine. I mean, that is
douchebag.
in the vast majority of cases, maybe all of them, a large capacity magazine is used. And the reason for that is because it has a particular capability. I would agree with, the colloquy with my
This
friend
has been
that
around
that
How long
basically
did
it's not a
change?
ban on weapons per se. It really is just a limitation on the total firepower that somebody has before they need to reload. So after firing 11 rounds with a 10-round magazine, a person just needs to take a few seconds and switch out the magazine, and they can fire 10 more
There's
rounds.
any limits on the number of semi-automatic handguns with 10 plus magazines that they can have?
But why
The
limit
number of magazines.
people who
The
aren't
number of
causing
magazines
the
and the number of
issue
handguns
because
that can
the
go with it.
people
No.
that-
No,
So they-
there's no such restriction in the district. You can
So,
have,
There is evidence here, it's in the declaration of Mr. Kleck, that mass shootings with large capacity magazines are in fact a very small proportion of the mass shootings.
that's fair enough, Judge
So it's
Ginsburg.
contrary to what you just suggested a moment ago.
Oh, sorry. What I meant to say was that all mass shootings are
Andrews-
conducted with large capacity magazines, or at least most of them.
Well, that's what I'm
Not that
saying.
all.
No, his numbers show that that's not true.
Oh, all shootings where, 10 or more people are killed. These are like situations where there's a mass casualty number are by and large used with large capacity magazines. I agree.
The standard definition for mass shootings is 4 or more fatalities, right? Or maybe it's victims, but
Certainly, many of those there were not large capacity magazines used, but I do think that
but it's, I mean, it's not vanishingly rare, but it is certainly the unusual situation.
that's,
In the most recent years, 21 going back, 5 of 28, 0 of 21, 4 of 31. These are outliers.
I think, you know, we certainly would dispute some of those numbers. I think many of those
Did
experts,
you have anything contrary to that in the record?
not in the record, because all of their declarations came in and attached to their reply brief below. So we actually didn't really have the time for
Which
the
numbers?
chance.
Which numbers would you dispute that Judge Ginsburg read?
My understanding is that many of the really, you know, mass shootings that have happened over the last few years were that large capacity magazines were used in those cases. But I'm not sure that that's sort of critical to our argument and if the
That
court.
makes sense if you've got a gun that's got 4 to 6 in it and there's 4 fatalities. But once you start, as you said, if your statistics, or if you believe their statistics are so, when there's more than 10 magazines, there's more than 10 deaths.
Well, I think that's exactly right, because it's much longer before a person needs to reload. And it's that moment where a person reloads that is a time when law enforcement or bystanders can come in and intervene. So that's really the purpose of this law. But I guess the basic point that I was trying to make here.
You have that in the record. Wasn't that your evidence?
Yes, and I think the basic point I'm just trying to make here is that, you know, at the end of the day, this is a judgment call. The legislature is trying to draw a line, and I took my friend on the other side to essentially be saying that the legislature can draw a line somewhere. That line, you know, they obviously want that line to be higher than the line that we've drawn, but they're not suggesting that we can't ban some large capacity magazines.
They are offering a criterion, which is to say common use.
And that's a pressure sensor issue.
That's absolutely correct, Judge Ginsburg, and we are also offering a criterion, which is common use for self-defense, which
Well,
we.
wait a minute, we also have a declaration showing that 65% or something like that of people who have large capacity magazines acquired them for purposes of self-defense.
But again, I don't think that it can be a subjective inquiry. I don't think it can just be that people feel that they
Then you
want.
don't really accept the common use criterion.
Well, I think it's common use for self-defense in an objective sense. I think the test has to be objective
other
and
words,
looking
you
at
have
the
to-
real
you have to
world
be shooting.
situations. Is a
Of
large
course.
capacity magazine actually commonly used in self-defense situations? We say the average number of bullets fired is 2. We also say that nobody needs the firepower where they can fire 11 rounds. And then all they have to do under our law is change out the magazine, which takes a few seconds. They have not put forward any coherent theory for why they need more than 11 rounds before simply having to change out the magazine in self-defense situations. And I
Logic
just
is
don't think that
fucking
is consistent
kryptonite
with the
to these
record.
It
people.
sounds, I mean, your argument is sort of that this law would go from being constitutional to unconstitutional once crime gets so bad that people start shooting more than 2 bullets self-defense.
Criminals aren't using
Well, I
10 round
don't think it's
magazines.
quite that. I think, well, first of all, 2 is obviously
28
far
rounds,
less
whatever
than
it is.
10. But in addition to that, I think we're
Hey,
just trying to
Glock
sort of
switches.
come up with proxies for trying to understand how to objectively ascertain whether a particularly lethal weapons accessory is actually useful for self-defense.
What do you make of the civilian marksmanship program that I think started in the 60s? Congress, I think, through the program, the government gives away rifles with high capacity magazines. And I think it's been distributed to something like 250,000
She's
high
talking about
capacity
the
magazines have been
M1
distributed. So
Iran program.
it seems like that suggests not only is there not a tradition
Oh,
of
God.
banning high capacity magazines, there's actually a tradition of the government providing people with high capacity magazines.
So I do think that there is some birth for governments to make different policy choices. The federal government in 1934 enacted the National Firearms Act, you know, severely restricting a whole swath of particularly dangerous weapons. If it made a different choice for a different type of weapon a little bit later, that's their prerogative.
Would
It's a
you-
different.
Would you agree that there is a tradition of the government providing some high capacity magazines to people?
There is some historical evidence, yes, but I think
Were
that's
those rifles or handguns?
rifles. They were
And
not
your
Which is not
statute,
before us on this.
and your statute bans rifles, right? High capacity magazines for rifles.
correct, though, at this preliminary.
Is it the
injunction.
only statute in history that bans high capacity magazines for lever action and bolt action rifles?
I don't know the answer to that, Judge Walker.
Do you know of any other statute that does?
Not off the top of my head, no.
And
It
this
certainly
goes to
hasn't.
sort of a lark, sorry. I don't wanna-
I just wanted to say, I don't think it has been applied to a
Bolt
lever
action,
action
swing,
rifle as far as
They
I'm
are,
aware, and that really hasn't come up before, so I'm not
Awesome
exactly
lead act
sure
has come
in
out
what
now.
ways it would
They-
apply to
they
that, so
are
I don't want to sort of overstep on that.
We also have no record on rifle perforce for the PI stage.
Correct.
Be developed at trial.
That's exactly right. And not only that, my friends on the other side have said, it is unrebutted that all of the semi-automatic handguns that they possess do accept 10-round magazines and that they have 10-round
My
magazines.
point
for them.
on the rifle is a larger point. I think the really 10,000 foot test that comes out of Bruin can't be an outlier. And your law seems like an outlier, right?
I think I would just push back on the notion that whether or not a state is an outlier is the relevant standard, because what that would mean is that the first state to act just can't do it under the Second Amendment. It has to be that states can sort of experiment within the bounds of the Second Amendment, of course, but McDonald made very clear that all experimentation was not off the table. And some
And that would be a pretty
responses.
good argument against the way the Supreme Court has done Eighth Amendment analysis, right?
Fair enough, Judge Walker, but I do think that the idea here is that states get to respond to local needs and local circumstances. They have some birth to make these decisions. We take this 10 number as a policy decision that is based on a history stemming back to 1994 when the federal government imposed that restriction. Firearm manufacturers then responded by creating 10-round magazines for all of the semi-automatic handguns that are in widespread circulation today. So I do think there's sort of been a coalescing around that number.
Unusual under the Eighth Amendment, the same as the Second Amendment? I thought they were different.
No, they are different, Judge Millett, and we would sort of, the dangerous and unusual phrase, we really think is a term of art. It cannot just be that unusual is a standalone numerosity requirement, as I've already discussed.
That's about the
Yeah, Warsaw, I would
three
be too.
factors after likelihood of success. I know your brief says that even if you were not to prevail on likelihood of success, that we should still deny the PI based on those factors. I wonder how the harm to the district should be thought of if I'm not saying we will do this, but if we were to find likelihood of success for the plaintiffs and limit the PI to the 4 plaintiffs. It seems very unlikely the district is going to be injured by these 4 plaintiffs unless you have some reason to think they are, perpetrators of gun violence.
I agree, Judge Walker. If the court were to limit the PI to only these plaintiffs, the harm to the district would not be as significant as what we have said in our brief would happen if the court enjoined the law across
Be
the
minimal,
board.
right?
I think it would be minimal. The only problem with that is I'm not sure why every other plaintiff would come in immediately thereafter, and it would just sort of result in this sea of litigation. And then eventually you would get obviously to a place where we think large capacity magazines would flood into the district. And this really happened in California. I mean, the plaintiffs have put forward no contrary evidence or rebutted the fact that for the 1 week in California where a district court judge did enjoin their large capacity magazine, 1 million large capacity magazines flooded into
I mean,
California.
it sounds like that means large capacity magazines are in pretty common use.
Well, they're certainly popular, Judge Walker, but I think, I've
Can I ask
explained
one more
why.
history, not necessarily. one more. Can I ask a history? Can I go back to the history inquiry? Do you read the Prohibition era laws
Cockeyed
to
bitch.
permit you to ban every
Friend of the-
semi-automatic firearm?
I'm pretty sure she cried. straight
no,
up.
I don't.
I think you have to say no because
At the
it's
same
not.
time.
Correct.
And then if not, why do those Prohibition era laws permit you to ban every firearm with a magazine of 10 rounds?
Well, so I think that sort of goes to the burden aspect, right? So when you're in this world where because of dramatic technological changes, you're looking for a historic analog and not a historic twin or a dead ringer. I think in that world, you're then looking to whether or not the prohibitions from earlier
It
eras
absolutely is,
have a
Brad.
similar burden on individuals' right to self-defense
Absolutely.
and were enacted for similar reasons. And the similar burden inquiry, I think, is why you can sort of distinguish those two things. In our view, really, our law allows individuals to have semi-automatic handguns with magazines up to 11 rounds, and as many magazines as they want, and as many handguns as they want. All it's saying is
No,
that when
you're
you get to the
misstating your
11th
law,
round you
douchebag.
fired, you have to take a few seconds to change out the magazine, which I don't think affects self-defense, minimally, if at all. But in an offensive situation where a person is trying to commit sort of mass murder, those few seconds can be the difference between life and death. They're the time that a police officer can come in and intervene, or a bystander. There's evidence of that happening in the real world.
And I think that is an eloquent way to frame the current regime. I think an alternative framing would be, you didn't used to give citizens any of those rights. It took a lawsuit in the Supreme Court for them to get what you're saying you now sort of so generously give them. The reason the Supreme Court ruled against you then, 10,000-foot inquiry, you were an outlier.
One car,
Look
you
at it
and me
today,
both.
you're still an outlier.
Well, I think I might push back that today we're an outlier. There are actually a number of jurisdictions that have these requirements in
How
addition to
many
federal.
jurisdictions ban high-capacity magazines for all guns?
I think it's 14 these days, which covers actually close to, I think, maybe 40% of the American public. But in addition, the federal government banned these from 1994 to
17 rounds, 20
2004. But
rounds.
even putting it, let's say we are an outlier on this to some extent. I don't think that what Heller said was simply look at the jurisdictions. The district is out of line with other jurisdictions. End of story. That would have been a very short decision. It is much more complicated than that. And I do think when you're looking at the historic
Another reason I say
justifications,
Heller was
we haven't really talked about this
shitty
too much, and I know I'm
But
over
the
my
national,
time.
real quick, though, the national ban, did that apply to, for high-capacity magazines, did it apply to handguns?
My understanding is that it was all large capacity magazines, but I could be mistaken about that. And on the dramatic technological change, I do think this is just a substantial change from anything that existed in the 19th century. Even as late as the 1870s, you had 0.2% of all firearms being able to fire multiple rounds. It wasn't until the 20th century that machine guns came on the market, and it wasn't until the 1980s that semi-automatic
What do you
handguns
think
could take
revolvers
large
were?
capacity
Or
magazines
multi-barrel
and
firearms,
sort of that started to
pepper box, stuff like
proliferate
that.
into society. So I do
to
think
make
there's really been
firearms
substantial changes
fire
here
faster.
that justify this kind of regulation, and that the regulation minimally affects the Second Amendment right. And we hope the court will affirm. I'm happy to address any other.
In Heller 2, we said, the prohibition of semi-automatic rifles and large capacity magazines does not effectively disarm individuals or substantially affect their ability to defend themselves. Now, we said that in the section of the opinion that was doing intermediate scrutiny, so that definitely would not work for the merits inquiry. But when we're at the preliminary injunction stage, trying to determine irreparability of harm, does a decision by this court conclude, it was on that record, but I don't know the material differences here, that the prohibition of large capacity magazines does not effectively disarm individuals, or more relevantly here, substantially affect their ability to defend themselves?
That language is highly persuasive, I think. I don't think I can say that Heller 2 is binding on this court. It applied means and scrutiny at the end of the day.
That's
which-
where this language, I thought we.
Correct, which
agreed the front end part of it probably is still binding on this court.
correct, exactly, right. So
And then also part of the back end, so definitely not right for the merits, but said on that record, at least, there's hardly any evidence that these magazines holding more than 10 rounds are well suited or preferred for self-defense or sport, but we're only talking about self-defense here. Is the record different in this case?
We should be talking about all legal purposes.
that-
was
that,
for
That they
all
are
legal purposes.
preferred for, well suited to or preferred for self-defense?
Well, on the preferred standard, as to preferred, I think that is sort of like a popularity type test. And so I think we certainly don't dispute that there are many of them out there and that they are popular.
Well, let's
On the
try-
well-suited, we certainly believe that they are not well-suited to self-defense.
We'll try something real fast. Hey, baby. If a criminal here is going to use any round capacity they can get their hands on, do you want more or less rounds, or at least the same rounds that the criminal is going to use?
I want more.
See, she wants more.
There's no such thing as a fair fight.
Again, no such thing as a fair fight.
They're not gonna play fair, so why the fuck should I play fair?
My wife is very intelligent. Whether or not she married me, it's questionable, but she is very intelligent. Yes. Why do I want to limit myself to a certain number of rounds, 10 rounds, when the gangsters are running around with 20-something round mags, 30-something round mags, and Glock switches?
Or the whole Second Amendment thing it was meant to give us the ability to defend against the tyrannical government, right?
Yep.
Why the fuck are we letting the enemy pick what we can use to fight them with?
That is a very good question. And if for those of you guys who didn't hear what Ms. Cook just said, the Second Amendment being able to stand up to a tyrannical government, why are we allowing them to choose what weapons we can use? How many rounds we can have?
Why are we letting the enemy choose what we can use?
It's like going into a boxing match and the other guy's got lead fucking weights in his gloves and they tie your hand behind your back and tell you, hey, just use your fucking face. What's up, Tread? Hey, Tread, today the House in South Carolina, it was like I tried to start a stream on it, but they just voted to send the or voted to amend concealed carry or constitutional carry and send it back to the Senate. It was like 2 minutes worth of content. They were just like, we're voting on this amendment. This is done. It's back to the Senate. So next week, I think I'll try to keep an eye on it, but next week's going to be the big fucking clown show. So yeah, be ready for that one. Yeah. Why do the criminals, and I was going to say government, but that's kind of the same thing. Why do they get to dictate what I use to get to defend myself?
Defense, because
Is there popularity difference? So this was 2011, so that's, you know.
I don't think it's,
The popularity
Defend.
change between 2011 and 2020.
there are more of them, but I don't think that as a legal, I don't think there's a legally,
So I'm wondering what preferred meant. Yeah. I should ask him, I know.
yes, Judge Ginsburg might have a better sense of
Are we
what
going to have
that
to dig
meant.
down stories with this?
I sort of read that to be more of a popularity type standard, but I do think that
Yeah,
the
I've had plenty of
suited,
those.
well suited for is sort of a good way to think about what Heller said about handguns and contrasting that with large capacity magazines, which we think are quite ill suited for self-defense purposes.
Thank you
Thank
very
you.
much. Okay, Mr. Wenger, we will give you 3 minutes. Sorry, I know you wanted we have other.
That's
other
no,
case to do.
I completely understand that, Judge Millett. So a few points that I want to make.
Before you do that, do you have the answer on how long they've been residents?
Oh, I actually did not grab that. I'm so sorry about that. So I
Can
just,
someone whisper it to you?
yeah.
I heard 1980 something.
Since 1988.
1988. Okay.
What was the
Sorry.
answer?
Since 1988. Okay, sorry, go ahead.
So going back to the start, quoting Heller, the Second Amendment, whatever the reason, the American people choose to put something in common use, whatever the reason, a categorical ban on a commonly used
Yeah,
arm,
Tread, they took out all
cannot
amendments and
withstand
sent a
second
clean
amendment
bill
scrutiny.
back to the Senate.
The Americans do get to decide what's useful. It's not a subjective test. And the objective inquiry
Is
is
it a
whether or not.
popularity test?
They say
I'm
whatever.
really struggling. hard
It's
to-
not a popularity test because objectively you can look and see what it is that America decides to arm themselves with for purposes of their self-defense.
How do we, this is just a fact question. I really don't know how this
Yes.
works.
Mhm.
I get that we know handguns are used for self-defense. That's just easier for a lot of reasons. My friend on the other side even mentioned it's accessibility, usability. How do we know that when folks are buying 10+ magazines, that was for self-defense? That is, that say they had before it, they had a 10 number magazine, 10 bullet magazine, or an 8. And then now they've purchased 16.
Mhm.
How do we know they did that to facilitate their self-defense?
We've put in the record that 64% of the people who own these plus 10 magazines have bought them for the purposes of self-defense.
Was there a survey that's?
There was a survey, Your Honor.
And that survey was done when?
Recently, I think it was 2021, I believe. So this is
The
recent.
totals in that survey are well over 100% because people have multiple reasons.
Correct, yes. They have multiple reasons to do that, but of the highest, 64% of the people who have owned this in that survey said that they own it for purposes of self-defense. And
They
these
own
are,
it-
these are,
they
I'll
own
be
the
right back.
magazine or they own the handgun?
they specifically owns the higher capacity magazine, ones that are banned by the district.
Smaller magazines? or
I don't
no
know
mag-
if-
No weapon at all, and then So I'm just trying to think, because if the
Right.
manufacturers are pushing these things out with the higher magazines, so that when you go to the store, that's just sort of what's on the shelf. It's hard to understand
Well,
these.
respectfully, Your
Maybe
Honor,
this is
there's,
too much factual stuff.
I mean, respectfully, there are in some jurisdictions, you can legally buy 50-round magazines. Those are not in common use for lawful purposes because the American people have decided they don't use those for common
Well, but they
purposes.
decided prior to the 1980s that they didn't use magazines over 10 for self-defense.
No, Your Honor, as soon as they became available,
But that's like the iPhone. As soon as it's available, I want the newest one. But if they're, I mean, I didn't see anything in the record where your client said that, or you had any evidence that someone wasn't able to defend themselves with 11 or less bullets.
that I think, so there is evidence in the record, and this is the Warner Declaration, paragraph 10. I've got the app site here, I can pull it up in a moment. But they basically said that these, even though they're not the typical self-defense, not that there's any typical self-defense incident, but they have
Someone
occurred
said
where
even though
people,
they're- Okay, go ahead.
these have occurred. There is a record that these actually have occurred where people have needed more than 10 rounds.
Where's
And
that?
It's
Hey, what?
the Warner Declaration. It is at appendix site 746, and it's paragraph 10.
But is that common use or has it just been a few times?
I want to make sure that I answered that question
Mhm.
in the context
Right,
of the
for
Second
sure.
Amendment. In the context of the Second Amendment,
Mhm.
limiting the rights of self-defense to the very act of pulling the trigger cuts the protections of the self-defendant basically down to 25%. Heller itself defined the term bearing arms as not only pulling a trigger, but wearing, carrying, making sure that you are prepared for whatever happens, no matter how rare. It didn't say prepared for whatever happens in the common situation based on the
Where is it on
statistics.
page 746?
Paragraph 10, I believe.
Paragraph 10. Well, the average citizen defensive gun use involves no rounds fired.
Mhm.
Where does it say? Oh, it just says there were situations where citizens fired more than 10 rounds and needed to reload their firearms. We don't have any sense of how many that is. We don't have any sense of.
No, we would concede that it's more rare than the evidence that's in there, but it does happen. And the right to bear arms is to be ready for
Mhm.
the unusual situation. The point about most self-defense uses not involving a shot at all really emphasizes the inappropriateness of that particular study. In most self-defense circumstances, pulling out a weapon and brandishing it will scare off somebody else,
Regardless of the magazines.
regardless of the. So based on that alone, if that reasoning tracks, you could ban all guns. You can ban all magazines because they are quote unquote not commonly
We did
used.
a preliminary injunction inquiry here and irreparable harm on their right to self-defense. That's the only context in which at least I'm asking these questions.
Correct, yes. And their harm on self-defense is that they are not allowed to bear a weapon to be prepared for that unthinkable circumstance where they might need to use more than 17 rounds. We're pausing to reload.
More than 17 now?
I'm sorry, that was a mistake.
Okay, sure.
More than 10, no. Excuse me. More than 10 rounds because pausing to reload for even those few seconds could mean the difference between life and death. That's the decision that the Second Amendment allows them to make. And I think that the really important quote from, from Bruin about
I
that.
should have asked DC this, but this is along the lines of your discussion about how many shots are fired and how often that is for self-help. But the military serves a national defense purpose, even when we're not at war, right?
Correct. Yeah,
Is there an analogy there to you?
absolutely there is. The ability to be prepared for the rare circumstance is covered in the very definition of what it means to bear an arm. It certainly is covered by the separate protection, the ability to keep an arm. And Heller made very clear that those are two distinct protections. So limiting the inquiry to the very act of pulling a trigger basically wipes out 75% of the plain text of the Second Amendment.
But insofar as we're looking at balances of hardship in the PI context, the imposition on, or the burden, I should say, on the Second Amendment right as you're claiming it would seem to be quite minimal because of the rarity, because of the district's point about the rarity with which a person in a defensive situation actually uses more than 11 rounds.
I still think that what we're talking about when we're talking about life and death situations and the ability to prevent those, on the very facts of it, that risk is irreparable. And I would submit to the court also that even on a PI, this court has held that the invasion of a protected constitutional right is itself irreparable injury. I believe that's Roman Catholic Church versus Cuomo. One important
Well, but there is, I mean, we are instructed to take account ordinarily of the burden, but even more specifically under Bruin.
Oh, correct. And so the imposition, the actual threat to the right here is the ability for my clients to bear an arm that they've decided is necessary for their self-defense purposes. It's, again, I'll emphasize, this is a right that pre-exists the Constitution. This is something that's part and parcel of being a United States citizen. Heller stands for the proposition that the American people, to Judge Walker's question, my friend on the other side, they are the ones, they are trusted to make these decisions. They have decided that these particular semi-automatic, higher capacity magazines are useful for self-defense. In the 1920s, they decided automatic weapons were not. They do make these decisions and they make them responsibly. One thing about that I really want to emphasize, I think that my friend on the other side is really arguing that we should defer to the judgment of the district about what is and what is not most useful. Bruin squarely foreclosed that, and I'll quote the language. While judicial deference to legislative interest balancing is understandable and elsewhere appropriate, it is not deference that the Constitution demands here. To the question that Judge Walker asked, the test itself from from Bruin, which they reaffirmed, is when the Second Amendment's plain text covers an individual's conduct, it presumptively protects that conduct. So that means that the very first thing is if the protection is to keep and bear an arm, if you have an arm, it is presumptively protected. If the government cannot
We
prove,
should wrap up here. We've actually given you
Absolutely.
more than your 4 minutes.
certainly, if the government can't prove a history and tradition, it can't categorically ban that arm. And the fact that something is commonly used for lawful purposes means that there is no history and tradition of banning that arm.
Thank you
Thank you,
very
Your
much. The case is submitted.
All right, let me do this other screen share. Yeah, I was trying to find something real quick because this is what happened in South Carolina today for constitutional carry. I figured there'd be a little bit more debate in the House on this today, but because look just how fast this went and what they did today. Let me see.
Oh my God, it's hot.
Screen share. This one. Yeah, this should be it.
To explain the amendment, Mr. Cox.
Thank you, Mr. Speaker.
Let
Ladies
me
and
know where the
gentlemen,
audio's all good.
this amendment, to recap, was our bill went over to the Senate, H 3594, which is
Yeah, this
Constitutional
is it.
Carry Act and Second Amendment Preservation Act of 2023. They amended it and sent it back to us. And what we're doing now is, after deliberation,
is it.
we're going to strike and insert our original bill back into what was sent to us from the Senate. After deliberation with the caucus, we decided this was the best bet to get this policy pushed across, because we have put in a lot of work, months and months actually of work.
And then we're going to end it
Collaborated
after
effort with
this.
law enforcement, Second Amendment groups, the governor's office.
Let me look up
And so we
things
felt
real
like we had put the rigor into it. Just to recap what actually is in our bill, I know it's been a year since we debated this, but this essentially expands the people of South Carolina's constitutional freedoms to protect themselves from constitutional carry.
2A and 3A.
It also empowers our law enforcement to stop the revolving door of illegal gun use and possession.
Yep.
This bill passed on a 90-30 bipartisan vote, which is a great victory. And our bill and this amendment would actually accomplish those goals that I just mentioned. You can actually own a pistol through a background check and carry that pistol wherever you can right now without a permit or permission slip from the government. This means that individuals and families can immediately start protecting themselves. The CWP program remains in effect for those who want to get training and have reciprocity, but is not mandatory to actually carry a firearm where you're allowed to. Secondly, and this is the more nuanced one, Section 16 of this bill actually addresses real gun crime and violence. There's been some confusion with this. Many times when there's a tragedy that occurs, politicians and anti-gun groups try to pass laws that restrict properly legally abiding gun owners when we don't address the real gun crime and the criminals that are committing crimes. Section 16 does this. It mirrors the federal level and statute for those who cannot own firearms currently. So as I said, as this bill came back from the Senate with their amendments, we debated it, we talked about it, and we realized that our bill is the best bill forward for South Carolinians to protect their freedoms and also to get criminals off the street. So we recommend the Senate take this up ASAP if this amendment gets passed. We look forward to working with them, and I move for passage, Mr. Speaker.
All right, Mr. Magnuson has a question. Mr. Cox, we accept his question. Mr. Magnuson.
Yes, sir.
Now it's for a question.
Thank you, Mr. Speaker, and thank you, Representative Cox, for all of your efforts on this issue. I know you've done a yeoman's job, so thank you for bringing this to our attention. And I had one question, and you may have mentioned this, but I missed it. Does this amendment reflect the exact language of the House bill that was passed initially?
Yes, the bill that was passed 90-30, this is the exact same bill inserted as an amendment. That's correct.
Have there been any changes to it?
No changes. We went with the bill that we researched, collaborated with law enforcement, as well as our Second Amendment groups. This is the bill that's inserted as the amendment of the bill passed as the House together.
Thank you, Representative Cox.
Thank you.
All right, seeing no further questions, the pending question is adoption of Amendment 1A substitute. All in favor signify by saying, who call for roll call? Mr. May call for roll call. Do non-members second the request? Non-members do. Voting on the board.
All right, so they're going to the vote now. You'll see how fast this vote goes. Red Dawn, I just made you a mod. Post your channel in the chat.
Mr. Wooten is recognized for a special introduction during the roll call. Mr. Wooten.
Yeah, they do a special
Thank you,
couple
Mr. Speaker.
special
Ladies and
introductions
gentlemen, if
and
I can have
shit.
your attention just a second, because we have a very special guest up in the
And then I'm
balcony
going
with
to
us
post
today.
a few other
Lance
people in the
Corporal
chat.
Marcos Grisette of South Carolina Highway Patrol. This is assigned to Orangeburg and Calhoun County. He is part of this year's LEAD SC program and is required to observe today's proceedings at the State House. I guess that's his punishment for the day. Ms. Cobb Hunter's here with me. We're honored to have his commitment
Here's
to the
the
citizens of
tactical
South
turkeys. They
Carolina
should
for
be
his
going live
participation
in
in
just a
LEAD
little
SC.
bit.
And we're also proud to have you representing the state of South Carolina wearing the uniform that you're wearing. Thank you for your service. If you could help me welcome him to the State House, ladies and gentlemen.
Welcome to State House, Lance Corporal.
Here's my
Appreciate
man
you being here today.
DLD. He ought to
Hope
be
you
going
enjoy your
live in a
visit and
little bit.
time up here.
If I don't see Red Dawn post his channel, I'll post it in just a sec.
Mr. McCravey is recognized during the roll call for a special introduction. Mr. McCravey.
Thank you, Mr. Speaker. We were honored to have Leadership Greer here today. If y'all would stand. And I think Phil Hamby is with them along with Tony Beam.
Here
Thank
is
y'all
Jason
for coming.
Ewing.
And we enjoyed having you.
Welcome to the State
And
House.
I
Appreciate you
got a
guys
couple
being
others I
here
gotta
today.
find.
Hope you enjoy your visit.
Let me throw my man Tactical Skillionaire out there. Let's throw Skilly.
Time has expired. Polls are closed. Clerk will tabulate by a vote of 85 to 26. The House adopts Amendment 1A. Clerk will read.
Amendments 2A, 3A, 4A, and 6A and 5A have been withdrawn. Number 7 has been withdrawn. Number 8A has been withdrawn.
I can see Red Dawn post this stuff.
Being no further amendments, the pending question is adoption. The pending question is adoption. Is to adopt.
All right. There's
Yeah,
Red
sorry.
Dawn readiness.
I'm sorry. Goes back to the Senate. Bill goes back to the Senate. No further amendments.
I got to get all those. So they'll vote on this. This thing goes quick. And it's right back to the Senate.
All right. Clerk
They
will
wiped
read.
out all the
Still on
amendments.
Senate amendments.
Still remaining on Senate amendments, we have Senate Bill 557, Senator Johnson.
Mr. Bannister, for what purpose do you rise?
Thank you, Mr. Speaker. I would move that we adjourn debate until March 19th
Yeah,
on Senate Bill
that was it.
557.
All right. Mr. Bannister moves to adjourn till March 19th. of
Ban-
So that's how quick the South Carolina House voted to wipe out all the amendments and send it back to the Senate. The Senate is going to be the complete clown show, I think. And kind of texting with Night Strike a little bit. He's the same way. The Senate's going to be the complete, absolute clown show. So anyway, that was oral arguments. I missed one part in those oral arguments that FPC mentioned earlier. One of the judges asking about Freedom Week, and they were like, well, how many magazines were ordered during Freedom Week? And they told them, yeah, a few million. And it was like, well, that kind of shut that decision down real quick, didn't it? Seems like people want these high capacity magazines, standard capacity magazines. We all know. And there's so much going on right now I want to cover. I could probably stream for the next 24 hours straight, not get to it all. But anyway, you guys follow all these guys. Follow, if you're not following Tactical Turkeys, hit them up. Most of you guys are already. Follow DLD After Dark. He'll be going live later tonight. Jason Ewing, you will normally see him and his wife in the chats and a lot of these channels, supporting channels as moderators and just hanging out, being cool people. Jason does have his own channel. He's starting to post more content, so follow Jason. Red Dawn Readiness, you guys saw him in the chat earlier. He's a good dude. Follow Red Dawn. Tactical Skillionaire. Follow my brother Skilly. Tread, we might have to do a 24-hour one time. I'll treat it like I used to when I was playing video games, man, and we'll start and run it. Because, oh God, we've done them. We've done some long ones. And a couple of them, I ran out of gas at the end of the damn stream. But yeah, we're gonna have to do some. Couple things. There's Law of Self-Defense. If you're not following them, look up Law of Self-Defense. Runkle of the Bailey. That's another dude. And I won't put him in chat this time. I'll put him in chat another time. I've dropped him before. They've done some streams in the last couple of days talking about these gun experts that are used in some of these cases. We've talked about another one. I thought it was the same dude, but this is another gun expert that doesn't think you should have ARs. They're not useful for, self-defense. You don't need these high capacity magazines, shit like that. And I probably still will do my own stream on that at some point. And maybe tomorrow, if I can get everything done soon enough, get back here early enough tomorrow, we'll do the one on the oral arguments for the 18 to 20-year-olds carrying that happened today. And again, if you're not following FPC, Firearms Policy Coalition, or Gun Owners of America and stuff on X or any of the other social media, you need to be following them because they're doing some serious work for us. So, but anyway, perps, I'm getting out of here. I still got to finish cooking dinner. I've been doing that. That's why I've disappeared a bunch of the stream, because I'm still doing that. So, and when South Carolina rolls back around and the Senate gets this bill back, I'll try to do some research and see when exactly they're going to take it up. So we know when that's going to happen. And when they take it up, I will either be streaming it live or I'll get with Night Strike. And Night Strike knew this was going to be quick today. He had other stuff to do, and he was like, yeah, it's going to be quick. Sometimes she does, and sometimes I do, Tread. She's come a long way in the cooking dinner department since we got married. What, 11 years ago? Something like that. 10 years ago. Yeah. Because for the longest time, I was the cook. Period. She had a couple signature dishes, which are still good dishes. Don't get me wrong. Curry chicken, off the fucking chain. But she is no longer a one-hit wonder. She has learned to do some serious cooking. And if you guys couldn't tell by my physique, I do some serious cooking sometimes. Yeah, well, a lot of time. But anyway, guys, I am getting out of here. Yeah, no kidding, Tread. If there's no way she could be with me if she wasn't right there as far as guns goes. There's no freaking way. I've been kind of in that position before, and it doesn't last because my sense of humor, I'm going to say some shit, they're going to say some shit, and I'm going to say a lot more shit, and that just, yeah, that boat sinks. But I am, guys. I got to get out of here. I'll show you my YouTube frame here. You guys be cool. Keep that thing on you at all times. Only something a lot more functional than this. It actually has a barrel and slide and the right components. And we'll be back covering this, man, as much as I can. And as always, any of you guys, man, if you've got something that you want me to cover that you see in your state or locality or anything like that, man, hit me up and we'll run it. A lot of times, even if it's not gun related, if it's still related to our rights, we can do it. I mean, we've done stuff on seizures before where, civil asset forfeiture, all kinds of stuff. We'll get into the nerdy end of a lot of that. But I am, guys. I'm out. All of you guys have a really good night, man. Get you some rest tonight. Chill out. We got a brand new morning starting in the morning. For any of you guys that are at work, have a good goddamn night at work. And we'll catch you guys on the next one, man. Love you guys. You perps are cool as fuck for putting up with me. And we'll see you soon, man.